Welcome to another immigration art video. My name is Art Serratelli, and together with Mijal, the two of us, we are the lawyers here at Serratelli Mijal PLLC. We do only immigration all the time. If you've got any question about anything concerning immigration law, feel free, send us an email. Give us a call. Email is your best bet. We answer, unlike other people, we are all over email. Our practice essentially is nationwide and worldwide. And if we don't answer email, the most efficient way to time shift, we got nothing. Zero. So we're responsive. Send us a message, set up a time to talk, and we'll go from there. Today's video is an overview, just an overview of the new regulations that the Department of Homeland Security through the USCIS published. To clarify, are you ready? To clarify the portability issues that govern when someone is in line for a green card and they want to switch jobs, or if you have an H-1B, if you lose your job, what is the rule that governs the gap between the end of the job you lose and the beginning of the job that you find after the fact? The regulations are being amended to clarify and improve the long-standing Department of Homeland Security policies and practices that have been implementing without regulation the American Competitiveness in the 21st Century Act and the American Competitiveness and Workforce Improvement Act, which will enhance the USCIS's consistency in adjudication. These rules that they're clarifying were written at the turn of the century. These rules were written 15 years ago. This should show you one thing. Immigration law is Byzantine. It is something out of the Dark Ages. And in the 21st century, we have to clarify with regulations the laws that were passed and put into effect in 2001. Are you kidding me? I'm going to give you an overview. If you want more specifics, send us an email. Mara, the crackerjack attorney at law here who runs the place and who knows the law inside and out, she's got a seminar, an American Immigration Lawyers Association seminar scheduled for this week. Between what I'm going to tell you now and what Mara is going to learn at the seminar taught by the American Immigration Lawyers Association, the two of us will offer you everything you need to know about these rules, which I will go over now in general to give you an idea of what's in there. Ready? Go. Point number one, we're trying to better enable U.S. employers to employ and keep high-skilled workers who are beneficiaries of approved I-140s. So the key to most of these rules, you need an approved I-140. Okay? Once you get that approved I-140, now you're stuck in the permanent residency immigrant visa queue as spelled out in the visa bulletin. If, as of the date of this video, if you're a master's degree holder from India or a master's degree holder from China, you're going to be waiting 5 years if you're Chinese, 9 years if you're Indian, between the time your I-140 is approved and the time you can file your 485. So these rules are supposed to make your life easier while you wait. The rules are supposed to make it easier for you to further your career as the worker, to the benefit of the employer. You're supposed to be able to get promotions and not mess up the paperwork. You're supposed to be able to change your position within the current employer who filed your papers and not mess up your papers. You're supposed to be able to change employers. You're supposed to pursue other employment opportunities under these new regulations, which are not new, which just simply clarify rules that were written 15 years ago. Point number 2. The amended rules are supposed to improve the portability for certain beneficiaries of an approved I-140 such that the petition will maintain its validity to benefit the employee even if the employer withdraws the approved petition or terminates the employer's business altogether. So if the business goes out of business and they got you an approved I-140, or if you are let go and you don't work there anymore and they withdraw the approved I-140, what does that mean? Point number 3. The rule is supposed to clarify and expand when individuals may keep their priority date when waiting in line and applying for adjustment to lawful permanent resident. What are the new priority date rules? They look pretty much like the old priority date rules. So don't get all excited. Okay, all right. Before we talk about point number 4, let's take a look and see where I've obtained, and more importantly, where you can obtain the rules, the details of these new rules that clarify the old rules. Source number 1. Here is the URL for the immigration website press release. There's the immigration logo. It's official. There's the press release title for what we're talking about. You can find this on the government website. You could use Emma. See Emma up here? She is your virtual assistant. We love Emma, but honestly, I'm an old guy. I'd rather just search the website. To the left of Emma, just type in what you're looking for. All right, now this is the Federal Register. See the URL up here? These are the detailed nuts and bolts rules and regulations. There's the title of the document you're looking for. This will be a laundry list of details. Mara is going to learn this at the AILA seminar. Hey, Mara will learn these details so you don't have to. We'll ask her. Point number 4. Now this is new. Check this out. This is good. It's going to allow you, the high-skilled individual working in the U.S. with an E3, an H-1B, an H-1B1, an L-1, or an O-1, to get this, apply for employment authorization for a limited period of time, even with a grace period that they're going to give you, which is also finally written in stone. if you are a beneficiary of, here we go again, approved I-140, and if your immigrant visa is not authorized for issuance because you're stuck with an old priority date that's dragging through the system, you're the poor Indian guy with a master's degree, then you're waiting 9 years, and your priority date's not current for another 5, and you lose your job, and you can demonstrate compelling circumstances. Compelling circumstances, what will that be? Mara will know. Compelling circumstances to justify the Department of Homeland Security issuing you an employment authorization document. Now, what does that mean? That means if you lose your job and you have an approved I-140, you can get a work card to go find work and work on the work card. Now, how is this all going to play out in detail? We don't know yet. Mara might get more information at her seminar. But in the meantime, I'll tell you this. That's not bad. You get an approved I-140, you lose your job as an H, you provide compelling circumstances to immigration, like, I can't pay my mortgage, my children will starve, get a work card. And then you are free to behave like a normal human being and find another job. And it's going to take you 3 months to get that card. You'll be lawfully present while you're looking for 3 months to find a job. Again, Mara will know more details. That's my reading so far. Now, such employment authorization that I just mentioned may only be renewed in limited circumstances and only in 1-year increments. Terrific. That's fine. Are you kidding me? You're going to give me a grace period. You're going to give me a 3-month application time to get a work card because I lost my job. I can get a work card and it's good for a year at a time. By the time I get a steady employer, I'll just get another H. This is good stuff. Grace period for 60 days, 60 consecutive days. And essentially, what it's saying is, if you're a high-skilled non-immigrant worker, they don't give much other identifying markers. I'm assuming H-1B. It may or may not be the E's, the O's, the L's. Mara will tell us more when she goes to that seminar. But in the meantime, here's what I can tell you. If your employment ends before the end of your authorized validity period. So say you have 3 years of H, and at the 2.5-year mark, bam, you don't have a job anymore. Then you get a 60-day grace period to pursue new employment and an extension of your non-immigrant status, meaning you get a new job and you amend and extend your old H-1B to simply get you a new employer on record and get you the remaining time you can get, up to 3 years, on your H. Remember to maximize the dynamic interplay among these rules. Don't just look at them in isolation. Point number 5. The rule is going to clarify H-1B provisions pertaining to how an H-1B is adjudicated. What are the elements of the H-1B rule that every adjudicator across the entire government will follow to make the outcomes of these cases more consistent? Joe Schmo with the exact same job as Sally Sue, Joe Schmo gets approved, Sally Sue gets denied. Same exact credentials, same exact employer. One gets approved, one gets denied. Why? The government is going to make that not happen again? Bull. I don't believe it. The reason I don't believe it? Because there's only a few requirements for an H-1B. Other than the prevailing wage, the education, and the job offer requiring the education, what's there to know? What is there to clarify? It couldn't be any more clear, in my opinion. It's going to clarify what the rules are. governing the period after you use up all 6 years of your H. If you're still in line waiting for the green card because you're the poor person from China with a master's degree and you're waiting 5 years, and they put you in line for the green card in your 4th year of work, and then you use the remaining 2 years of your first 6 years of H, but you got 3 more years to wait to get to 5 years to get the green card. What do you do when you run out of your 6-year H? Well, we all knew what to do in the past. Now they're going to clarify in writing what we've been doing all along. Big deal. Don't get so excited. The government's also going to clarify the rules to determine the cap exemptions and counting workers under the H-1B cap. So essentially, the government's saying here, we're going to issue rules to make sure that when you say something is cap exempt, you know what we, the government, are thinking about what is cap exempt, because we may have very different interpretations, which should not be the case because there's a law. And the law says this: if you're a college or a university, employer type 1, if you are a nonprofit research organization, employer type number 2, or if you are a nonprofit affiliated with a college or a university, employer type number 3, you're one of those 3, you get cap exemption. What's there to talk about? We're going to find out. Mara will know. Point number 6. Now this is new. The rule establishes 2, not 1, 2 grace periods of up to 10 days, 10 days each, for individuals with E1, E2, E3, L1, and TN non-immigrant classifications. Sounds like we're going to have 2 grace periods of 10 days each, 1 at the beginning, 1 at the end. The 10 days at the beginning of, again, E1, E2, E3, L1, TN. There's no H in there. There's no O in there. These rules essentially allow you to, number 1, prepare to begin employment in the United States, and at the end, wrap up whatever you're doing and go back. So you'll have a grace period, kind of like OPT. Point number 7. There will be automatic extensions of employment authorization and the validity of employment authorization documents for certain individuals who apply on time to renew their EADs. If your EAD gets messed up and it doesn't come 90 days according to law like it's supposed to, if it gets lost in the mail, some of my clients, they get their EAD cards approved. We get an approval notice. Do they ever get the card? It's lost in the mail. If that happens to you, this will fix it. It's an automatic extension, and you worry about the paperwork and the card, the new card, catching up to the automatic extension. You're covered. We're not going to leave you high and dry with no card. That would be rotten, and that's what's happening now. Rotten things. So this will fix it. This is good. Eliminate the regulatory provision that requires USCIS to adjudicate. This goes hand in hand with the other one. Eliminate the regulatory provision that requires USCIS to adjudicate the I-765 application for a work authorization card within 90 days. In cases where such adjudications are not conducted within the 90-day time frame. So the new rule is, we need it in 90 days. We're required by law to give you the card in 90 days. But you know what? If we don't do it within 90 days, we're going to pretend like that rule isn't there. Government work. Can you imagine? Can you imagine if you got away with that at your job? Can you imagine? If you want more information, we've got answers. We love what we do. We're here. Your email is your best bet. Send us an email and we'll get the conversation started.